more reading, this time with music, because I feel like it's for me. That's right. So, anyone who dirties a water supply is so obviously offensive that one might suppose law would regard it as an act, would regard the act as a wrong, if not a crime. But in fact, law is schizoid on this point. As a psychology major, I am not quite sure of that word. I don't think we should be using it in the way that this book is using it, but that's not the point. So, sometimes law seems to take the position of most people that a little bit of dirt never hurt a great big body of water. In other moods, because men are so dependent upon drinking, power, irrigation, transportation, law has developed a vast amount of statutory and judiciary regulation. These often vary with the different interests and needs of society that develop them. Arid states in the West and moist states in the East have quite different codes. This diversity is as great on pollution as on anything else, and understanding of law in this field is complicated by its inability to reach very clear conclusions as to what pollution actually means. In fact, sometimes one suspects that law has no certain definition for water either. One of the problems of law is that science frequently has no answer to simple questions. Just how much does this process or practice foul the water? That's all we need to know. Can't figure it out, apparently. The same is true of air and soil and pollution too. Like, law just cannot figure out like the exact. Law is not exact enough to create laws. Seldom, if ever, is a new technological advance postponed to determine what eventual side effects it might have on the environment, which also is similar to Plan B. It has not been in practice used long enough, I feel like, for people to actually know of the long-term effects. And I'm just saying, let's just start doing birth control on the men, okay? Like, sorry, it's a bit off topic, but I'm the only fucking one that's meant to be watching these, and I'm gonna complain about the little things that I feel like complaining about, and later on, I will touch back on them for myself. But I do like this book. So, seldom, if ever, is a new technological advance postponed to determine what eventual side effects it might have on the environment. Law has not reached the point of holding, as Senator Edmund S. Muskie, for one, suggested about the discharge of wastes from any source. You've got to take on the point of view that if we don't know enough, we don't know enough to permit the discharge. Taken literally, that point of view would have delayed indefinitely the production of nuclear power and a host of common household and industrial projects now taken for granted. Who's playing this racket in the background? How dare you? Nearly all water that anyone worries about is public property. Everything navigable, rivers, ports, the Great Lakes, etc., is controlled by the federal government. Since, since the 1899 Rivers and Harbors Act, the Army Corps of Engineers has been the agency chiefly responsible for them. How did you just touch my hand? Oh, cute. Other streams that law calls meandering, and lakes that are not completely within a proprietor's own land are subject to the rules of the states. People on the banks have varying rights depending on the state, but the general rule is that they cannot do anything to or with the water that adversely affects the people downstream or across the lake. Neither legislatures nor courts have spelled out just how adverse the effects have to be before law steps in. Even wastes that clearly poison the water would have been permitted, or at least law does not prevent them until once pure rivers and lakes become no better than open sewers. At last, accelerating damage from an accumulation of technological offenders, and the scientific proof of that damage, is moving law to protect the water while something remains to be saved. Public demand for such action has proved so strong that law has forced even the biggest sacred cow of our time, the high-speed automobile highway, that monster created in the name of progress, to yield at least once to a waterway. The damage feared was no threat to health or safety, but to what one of the judges who heard the cause called scenic, historical, and recreational values. The body of water rescued in this instance was the Hudson River. Many New Yorkers, including the state legislatures who set up a Hudson River Valley Commission to encourage preservation and enhancement. Many New Yorkers, including the state legislators who set up a Hudson River Valley Commission to encourage preservation, enhancement, and development of the scenic, historic, recreational land and natural resources of Hudson Valley, believed that law already had assured this result. But the commission was also charged to encourage the full development of the commercial, industrial, agricultural, residential, and other resources. So when, in 1968, the New York Department of Transportation submitted to the commission plans for a 6-lane expressway that would run for 10 miles on land to be filled in along the East Bank for as much as 1,300 feet out from shore, the commission issued a finding that the project would not have an unreasonably adverse effect on the scenic, cultural, recreational, or historic resources. The commissioners may have been influenced by the fact that the east bank of the Hudson in this area, from the New York Thruway Bridge across the river at Tarrytown or Crotonville, is hardly a beautiful spot. The Penn Central Railroad runs along the waterfront, and a great many drab industrial and commercial buildings line the tracks. But it can be argued that adding one eyesore to another was not the purpose of the act of creating the commission. Two organizations, the Citizens Committee for the Hudson Valley and the Sierra Club, plus 3 residents in the area, took that position. They sued in state court to have the commission's findings set aside, and the Department of Transportation enjoined from proceeding with the expressway. They lost. The judge virtually branded their objections as mere quibbles. The expressway also needed the consent of the federal government, and on January 27, 1969, after the state was decided, the New York Department of Transportation obtained from the Army Engineers and the Secretary of the Army a permit for a dredge and fill operation that would dump a shit ton of cubic yards of rock and dirt into the Hudson. The rock wall was to keep the fill from sliding out into the middle of the river. The plans for this made land to be connected to the bridge approaches as its southern land by a causeway. What? This sentence doesn't make sense. The plans called for this made land to be connected to the bridge approaches at its southern end by a causeway. I think we need to take out the approaches. Okay, the plans called for this made land to be connected to the bridge at its southern end by a causeway, whereupon the Citizens Committee and the Sierra Club, joined by the village of Tarrytown, but without the residents, went to a federal court to stop the expressway. They chose procedural and technical grounds rather than an attack on the engineers' judgments. The defendants were now the secretaries of the Army, Transportation and Interior, the Chief of Army Engineers, and the Commissioner of the Transportation for New York. The Citizens Committee and the Sierra Club, acting as private attorneys general, really wanted the expressway forbidden because they believed that it would impair the scenic and other non-economic values of the river, but they argued this only indirectly. Tarrytown said the village would lose money because of lower property taxes, but the main thrust of the argument was that the Army engineers, and indeed the whole executive branch of the government, were without authority to permit such an expressway unless Congress specifically approved. The defendants not only denied this, but protested that the plaintiffs had no standing to sue because they were not hurt yet. The committee and the club had no personal economic claim to assert, and Tarrytown's property values could not be reduced merely by the excavation fill, but only when a road was put on top. The federal officials also held that the decision as to a balance between beauty and utility between nature lovers and motorists rested in their hands. Finally, the government lawyers contended a district court has no jurisdiction to review a decision by the Secretary of the Army. Judge Thomas F. Murphy had no trouble in allowing that the committee, club, and the village had standing to sue. Less than 3 years earlier, the Scenic Hudson Preservation Conference had won its right to question the Storm King project only a few miles away on the other side of the river. It was almost exactly the same interests to show as to those of the committee club. The village was right to center the case at this stage. For if it waited until the state had gone to the enormous expense of those millions of tons to fill, it would be too late to halt even an illegal project. As to jurisdiction, he pointed out that while the court was not authorized to review specifically the Secretary's decisions, these fell within a general statute permitting suits that questioned final agency action for which there was no other adequate remedy. The judge also noted that the Supreme Court had interpreted this to mean that jurisdiction over complaints involving federal agencies should be restricted only upon showing a clear and convincing evidence of a contrary legislative intent, of which no suggestion was introduced on behalf of the Secretary of Army. All of this was prologue. It hardly touched on the issue at stake, whether the Army engineers had exceeded their authority in granting the permit. When arguments did reach the main point, both sides relied on the wording of the Rivers and Harbors Act of 1899. Each cited a different section. For the government, the key sentence read, "It shall not be lawful to excavate or fill in a navigable waterway unless the work has been recommended by the Chief of Engineers and authorized by the Secretary of the Army." The plaintiffs called attention to a previous passage which provided that when a bridge, dam, dike, or causeway was involved, the consent of Congress was also essential. Later legislation gave advance congressional consent to any bridge approved by the Army engineers and transferred causeways to the Secretary of Transportation, but dams and dikes were still covered. The point of law narrowed then to whether the permit issued was only to excavate and fill, which was within the sole jurisdiction of the Army, or also for a dike, which would then need the consent of Congress. The government found a definition of dike in a technical dictionary first published 40 years after the Rivers and Harbors Act was passed. This limited dike to a wall built as training works for a river so as rigidly to confine flow within definite limits. The expressway wall was not anything like this. However, as Judge Murphy pointed out, the engineers had actually called that wall a dike several times in their permit. He also quoted newer dictionaries as defining dike as an embankment to control or hold back water, or to serve as a barrier, which was obviously the intention here. The Murphy decision granting an injunction against the project. That's a bit distracting, Hold it up. The Murphy decision granting an injunction against the project was handed down on July 11, 1969. It was confirmed on every point the following April by a three-man court of appeals in an opinion that went a little deeper to the real concern of suing conservationists, what the expressway would do to the river. The three judges did not say just how much weight Army engineers had to give to fish and wildlife conservation, pollution, aesthetics, and ecology, but they pointed out that various regulations required the engineers to evaluate all of these relevant factors before granting a permit. The plaintiffs had argued in both district and appeals court that the Corps had arbitrarily and capriciously ignored these factors. The judges, having ordered the project stopped because it involved a dike that needed congressional consent, declined to consider the more difficult problem of the expressway's full effect upon the river. The appeals judges mentioned beauty, and the rest only in connection with the standing of the committee and the club. The concern of the two organizations for these factors, apparent from the considerable expense and effort they have undertaken, gave them the right to sue. Whether they were correct in their appraisal of the damage that the expressway would do, the judges could not say. The practical effect of the decision was to end plans for the expressway on the Hudson River, for on December 7th, 1970, the Supreme Court refused to review. Any attempt to push an authorizing bill through Congress would clearly meet another more public opposition than either house would care to encounter. So on the philosophical side, it could be considered that laws ruling in favor of a river against a high-speed road is a triumph of conservation over technology. But a skirmish is not a war. Indeed, those who want to know just what law requires of the Army engineers in the way of preserving a river's natural state are no better informed than they were before the expressway was planned. Older and more persistent than efforts to enlist law in the protection of beauty can be the crusade for purity. Legislatures and courts have spun off thousands of statutes and opinions designed to prevent or correct water pollution by individuals, corporations, or public agencies. Both civil and criminal procedures have been invoked against the householder who throws his garbage into a lake, the company that spills or leaks oil into a harbor or offshore drilling site, and the municipality that releases raw sewage into a river. Lack of enforcement rather than lack of law accounts for much of the pollution that exists. Also, many statutes that set standards exempt existing homes or factories or sewage systems or allow them a long time before they need to stop. Some contaminants were not known when the laws were passed, and so are not always covered. 12,000 chemicals that have toxic effects in waters are now used in industry. 500 new compounds are introduced every year. Inspectors of water supplies usually find out about the new ones only after they have been getting into the water for years. The Federal Bureau of Water Hygiene in 1970 surveyed 969 systems ranging in size from that of New York City to rural Vermont. Of the many people served, about 2% were drinking water of potentially dangerous quality because of disease, bacteria, and toxic metals. Many more of the thousands of samples taken showed amounts of various chemicals higher than the federal standard, but not yet dangerous to human health. However, some accumulate in gradually increasing amount because they do not dissipate in water, and treatment plants are often not equipped to deal with them. At the present stage of law and science, strict enforcement of all the regulations promulgated to clean the nation's waters would bring industry to a halt. The dilemma can be seen quite plainly in the legal history of just one of the best-known chemical polluters, dichloryl diphenyltrichloroethane (DDT). The insecticide hailed as a savior and damned as a destroyer within the span of 2 weeks. It was put together in Germany 1874, but not until 1939 did Paul Mueller of Switzerland discover that it killed insects carrying disease, and thereby won the Nobel Prize. During World War II, DDT was dusted over millions of dirty people, soldiers coming out of combat and refugees hardened into crowded camps. Then it was sprayed to kill malarial mosquitoes and pests that infest crops or cattle. Enthusiasts predicted a world free from every deadly or unwanted pest, from houseflies to Japanese beetles. Rachel Carlson's Silent Spring shattered that fond illusion in 1962. One of the rare books that has changed the practices as well as the thinking of its readers, it explained dramatically why the effects of DDT and other miracle pesticides that science was discovering were less than utopian. For the first time, the public learned a few deadly facts about DDT. Its poisons, so effective against insects, kill other animals too once they get inside the body. The poison builds up, perhaps for years, collecting in organs that are rich in fat, such as the liver or the kidneys. Animals die from it because they eat other animals that have absorbed DDT or plants sprayed with it. Bees get killed along with the flies and the mosquitoes, and species of flowers that rely on bees for pollination die out. The chemical is virtually indestructible. Insoluble in water, it is carried by rain and groundwater into streams and lakes, passing from grub to fish, from berries to birds, from hay to cows. Miss Carson and her successors traced the devastation of whole areas of once pleasant countryside to DDT. 4 years after Silent Spring, in 1966, DDT inspired formation of one of the first organizations to engage man's pollution of nature in legal combat. On April 25th, a 31-year-old Long Island lawyer, Victor J. Yanacone, filed what is called a class action against the Suffolk County Mosquito Control Commission. On behalf of his wife Carol and all other people in the county, although he had not asked most of them, he demanded that the commission be enjoined from spraying DDT on local marshes, because one of the side effects was to kill fish in a lake. He called an ecologist, a biologist, and an ornithologist as expert witnesses. Ornithologist. An ornithologist. They so impressed Judge Jack Stanislaw of the county court that he issued a temporary injunction on August 15th. After hearing testimony and arguments for 6 days, he kept the injunction in effect for a year before he withdrew it, then reinstated it when Yanacone demanded further hearings. Finally, the judge withdrew it again, ruling that although DDT was harmful to wildlife, the commission was justified in using it for the protection of the people. Meanwhile, Yanacone, with some of his witnesses and other interested individuals, had incorporated the Environmental Defense Fund. In November 1966, they undertook their legal crusade against the Mission Department of Agriculture, which was preparing to spray from the air to get rid of Japanese beetles on orchards located in Lake Michigan's watershed. The chemical to be used was dieldrin, which is about 50 times as toxic for birds and animals as DDT. The State Court of Appeals at Grand Rapids granted a preliminary injunction but vacated it after a 6-hour hearing on the ground that the department had not exceeded its authority. The Environmental Defense Fund has been joined as a legal gladiator by a number of other organizations committed to protecting water, air, and land from a man and machine. More significant than the cases they win in court is the impetus that they give to the public to a public demand for more vigorous law enforcement and for adoption of new legislation to block loopholes. The approaching end of the DDT story illustrates this point too. First of all, federal rules on use of pesticides grew stricter, requiring more explicit warnings of danger, and then imposing actual restrictions on spraying. By early 1970, the United States Department of Agriculture, which then regulated DDT, ordered no more spraying of tobacco fields, marshy areas, and around homes. Officials spoke of a possible complete prohibition. The Environmental Defense Fund did not drop its court action. On May 28, 1970, the U.S. Court of Appeals for the District of Columbia found for the fund in 2 DDT suits. Found for the funds? Found for the fund? What the fuck does that mean? Found for the fund. It's a bit bright here. Yeah, it's like blazing on the face. One commanded the Secretary of Agriculture to halt the registration of DDT for any shipment across state lines or give reasons for not doing so within 30 days. The other ordered that a proposal to forbid the spraying of DDT on any farm produce that was consumed raw should be published in the Federal Register. A few days later, the fund won, without court action, a suit that the National Audubon Audubon Society and the National Wildlife Federation had brought against the Army, the Corps of Engineers, and the Olin Corporation. Olin manufactured about 1/5 of all the country's DDT in buildings leased from the Army at the Redstone Arsenal outside Huntington, Alabama. Hold on, this is killing me. I mean, like, ow. I'm tired of it. It's not killing me, but I'm tired. I know. Okay. Yeah, it's one last. Okay. Olin manufactured about 1/5 of all the country's DDT in buildings leased from the Army at the Redstone Arsenal outside Huntington, Alabama. Wastes from this plant flowing from the Wheeler National Wildlife Refuge contained more than the allowed 10 parts of DDT per billion parts of water it was charged. Some animals in the refuge were said to have been found with lethal accumulations of the chemicals in their tissues. Before the suit was brought, the Federal Water Quality Administration, a new agency created by Congress to set and perhaps enforce standards of purity, had recommended that the standard be 20 parts per trillion of water. This the Army rejected on the grounds that Olin was reducing the amount of DDT in the waste as fast as it could. The 3 conservation organizations argued that this was not good enough, and their court action followed. On June 8th, before it came to trial, Olin decided to close down the plant altogether, issuing a graceful statement saying that the continued operation would not be consistent with the company's own ecological policy. The legal fight on DDT moved onto the broadcast possible national scene. The fund still among the litigants. It's weird that it's called the fund, isn't it? Isn't it a bit weird? It was in a private attorney's general suit to compel the Environmental Protection Agency, recent successor to the Agriculture Department as regulator of DDT, to institute at once the steps necessary to bar DDT from interstate commerce. On January 6, 1971, a federal court in Washington issued an order, and the agency announced that it would not seek an appeal. The fight over DDT led to wider airing in public of many other insecticides, herbicides, fungicides, and other new killers devised